May be seated. Good morning, ladies and gentlemen. We are here for rehearing en banc in the case of Skidmore versus Zeppelin. And remember to silence your cell phones. Thank you. You may proceed. Yes.
Thank you. I'm going to reserve 15 minutes for rebuttal. I understand I have to watch the clock on that. May it please the court, may it please defense counsel, may it please everyone in this courtroom. My name is Francis Alexander Malafi of the law firm Francis Alexander. With me here today is my partner, A.J. Fleur, along with Glenn Kulik, and also plaintiff Helen is here in that back row. Justice is the search for the truth, and that's the ideal we strive for, whether it's in the state, whether it is the country, or whether it's the circuit. And when we don't find that truth, we have to ask ourselves why. And when we ask ourselves why, we have to consider whether or not we've exalted form over substance. And if we have exalted form over substance, we have to look and determine whether or not that's fair, that's equitable, or whether or not exalting form over substance is supported by the law. In this case, the answer is no. And it's not because I say it's no, it's because this court says no. This case, the underlying trial, the panel opinion, which we respect, we have one issue, and that issue is the form over substance issue, and that issue is whether or not we were ever afforded the consideration of the prejudice analysis in Three Boys Music. Three Boys Music is the law in this circuit. Three Boys Music says very clearly that absent an intent to defraud, inaccuracies in the deposit copy, the court is given broad and deferential consideration to not consider them and look to other evidence, best evidence, better evidence. But there's one thing. Neither in the trial court, neither the panel opinion, was that prejudice analysis ever considered. And what prejudice analysis is there? It's the prejudice of whether or not, one, we can identify the work at issue. Everyone knows the work at issue is Taurus. So then it goes to, well, if we can identify the work at issue, there's no prejudice there, then it goes to what if there's any prejudice to defendants. Let's consider the prejudice to defendants. We know, because we have testimony, in our opening brief, page 41, excerpt page 507, 508, Jimmy Page never went to Washington, D.C., and went to the Copyright Office, never pulled out a dusty lead sheet of Taurus, never copied from Taurus, right, from the deposit copy. So why are we looking at this artificial analysis that never happened in the real world? It's wrong, it's artificial, it's imaginary. What we do know, and what we proved at trial, was that Jimmy Page had 5 of Spirit's albums in his record collection. What we know is that he was a fan of Spirit. What we know is he opened for Spirit in their first U.S. show. He opened for the band. He was familiar with the band. And he liked them on an emotional level. But what did he have in his record collection? The same side as the song Fresh Garbage, which they performed live many, many, many times. The 4th song was Taurus. Jimmy Page admitted he can't read music. He never read the deposit copy lead sheet. He never saw that.
What work, in your view, is entitled to copyright protection?
I'm sorry?
What work, in your view, is entitled to copyright protection?
If we're shifting to substantial similarity.
No, I'm asking a question. What work is entitled to copyright protection? That should be simple.
In this case, we believe that it's the full composition as embodied on the album recording.
So not the deposit copy, but the album recording is what you think is entitled to copyright protection.
I think
yes. Yes?
I think that, yes, that is true in this instance. But I think in a perfect world, the deposit copy would fully embody the full composition.
Okay, but in this case, you don't think the deposit copy is what was infringed. You think the sound recording was what was infringed, correct?
I think that we have to look at the prejudice analysis of Three Boys
I'm
Music.
not asking about prejudice analysis. I'm asking a very simple question.
In this instance, yes.
So what case do you cite for the proposition that not the deposit copy, but a subsequent sound recording is entitled to copyright protection?
Well, I think we go to the Three Boys Music with the prejudice exception. I'm sorry.
What do we do with ABCO Music that says that under the 1909 Act, sound recordings are not protected? What do we do with that case?
I think we have to look at the White-Smith case. The White-Smith case said that copies can only be sheet music. So what happened was it invited Congress in 1909, through the 1909 Act, to expand it past sheet music to look at what? Piano rolls or mechanical reproductions. A piano roll, which is a mechanical reproduction, which does embody the composition.
But you just said in response to Judge Hurwitz's question that the copyrighted piece was the sound recording, but our case law, ABCO Music v. Levere, says you can't get a copyright on performances and sound recordings under the 1909 Act.
I think I would make it a little more clear. I don't think it's the sound recording that's the copyright. It's the composition embodied in the sound recording. And it's the same as...
To be clear, you want to take the sound recording and essentially reverse engineer what would be the sheet music for the sound recording? Is that what you're arguing?
What we know is that...
Yes or no?
I think you could look at it that way, yes.
What's your best authority for that?
For reverse engineering it, would be looking at Three Boys Music, which says absent prejudice, absent intent to defraud, absent... even if there's inaccuracies in the deposit copy, you can look to other evidence, including the sound recording, which was done by...
Three Boys says that can be evidence. You seem to be taking a broader proposition. You seem to be taking the proposition that the sound recording is itself protected by copyright, which is why I asked the question.
It's the composition embodied in that sound recording, not the actual sound recording itself. That happened later. We never made the argument that this is a sound recording copyright. We made the argument that embodied in mechanical reproductions, embodied in piano rolls, embodied in sound recordings is the actual composition.
Is the argument then that the deposit copy, in this particular case, there's no infringement there, but there's infringement if you take the sound recording and you basically embody it into notes on a sheet, and that's what was infringed upon?
I would say yes, that's one way to look at it, and I think that's accurate in this instance. Why? In a perfect world, a deposit copy, lead sheet, would be exactly the same as the composition. But when that isn't so, and when there isn't prejudice, and when there is inaccuracies, however large the magnitude, the courts have broad and deferential treatment to say, okay, what's the better evidence? The better evidence is the evidence that Jimmy Page and Robert Plant had access to, not something they never saw. So if he copied, let's break it down, a logical argument. I'm sorry.
You base a lot on something they never saw.
Right.
I mean, when you look at copyright cases, they're not predicated on the notion that the infringer actually went to the Copyright Office to see what was deposited. I mean, that's just a fantasy that you're talking about.
And that's the alternate reality that doesn't exist.
Of course not, in any copyright case.
I would say no, because, and let me share with you why. Copyright, you have to prove ownership. We did that trial. You have to prove access to a piece of work. And then what's the second part logically? You have to show not only access to a piece of work, but copying from that piece of work. If we're showing access to a piece of work, but copying from something else, it's an artificial analysis. It exalts form over substance.
And well, perhaps, but are you conceding today that if you are confined to the deposit copy, your copyright claims are are not viable?
I think that it is very difficult for plaintiff to win based on the deposit copy because it was such an inaccurate transcription of the composition which Randy California wrote. Let's be clear. Randy California never wrote the deposit copy. Randy California never...
So is that a yes? That if we were limited to the deposit copy, then there would be no infringement because that's not, as you say, an accurate reflection of the sound recording. But if you were to set aside the sound recording and focus just on the deposit copy, then plaintiff could not prevail?
I think there's two aspects to that question. The question is, do we look at it in the concept.
Counsel, that really was a yes or no question. It would be helpful to all of us if you would answer it yes or no.
I think, yes, I think that is the reality of the situation because the inaccuracies are so drastic.
Is what your original work then is the claimed 2 minutes and 14 seconds of the sound recording? Is that the copyright that you're claiming?
No, it's the composition embodied in the album recording.
Is there
Okay,
any
well,
case
let's say
that-
what that is, though. The composition of what? The 2 minutes and 14 seconds?
Right.
Okay.
Correct.
Is there any case that takes the position that you're taking, which is that a sound recording, there's no copyright available in the sound recording, but nonetheless you can write down the transcript of the sound recording and somehow that is separately copyrighted by the copyright of the deposit copy? Or is there any case that says that?
Well, I think there's a few steps I have to work through to get to that answer and to answer your question fully. 1908 White-Smith case basically said that only sheet music are copies, and therefore there can be no infringement. Invited Congress to expand the scope. Congress came back in 1909 Act and said, you know what? Piano rolls are capable of embodying the composition. A piano roll is no different than a sound recording, not for the purpose that...
But what you've said is that the sound recording does not embody the deposit copy. That's your whole point. Because if it were just the deposit copy, it wouldn't be anything like what you're claiming has been infringed. So I'm asking about whether there are any cases that jump through all of those hoops that you want us to jump through.
You really look at two cases. You look at Three Boys Music, and then you also look to Williams v. Gay. In Williams v. Gay, so long as it's represented in the deposit copy, it's okay. The deposit copy and the sound recordings, that composition is embodied in the deposit copy as well as the deposit copy is embodied in the sound recording. The issue is it's inaccurate and it's not fair to exalt form over substance when everyone knows the piece at work at issue which Jimmy Page had.
The Three Boys said that they would not disturb the jury's verdict that Isley Brothers had deposited a complete copy, even though there were inaccuracies in it. And they had an expert testifying that the deposit copy included all of the song's essential elements, such as the title, hook, chorus, and pitches. Is that the same in your case, that it was a complete copy and had all essential elements in the deposit copy, even if there were some variations? I
think the court said that even although there's inaccuracies, so long as these things are represented in some way. And that's what
they said all of the essential elements were included. Were all the essential elements included in the deposit copy in your
I would
case?
agree, yes, the essential elements, the descending chromatic scale, the key. Some things are left out, like the rhythm and the tempo, but we know what those are because we know the piece of music at issue. There's no prejudice. So although it's not like the deposit copy is completely foreign to the album recording, it's just a bad transcription. We know what we're talking about. We know there was inaccuracies. We know that there's no prejudice to the defendants. He had it in his record collection. We proved access. Access to what? To the album recording. And then we're making an artificial comparison to something that doesn't exist in the real world. Why does Led Zeppelin, why do defendants not want to hear the album recording? Because they will absolutely lose the case. The case could have been tried.
And you lose the case unless they do.
I think we're very challenging.
100 times out of 100, right?
No,
I mean, you listen to these two recordings, the deposit copy and the performed copy by Led Zeppelin. I don't see how any juror could find them substantially similar, even with expert testimony. So you've got to get your sound recording in order to win this case, don't you?
We have to bring in the best evidence and with the fair evidence.
Well, you got to get it in to win, don't you?
I think so, but there is some leeway, as in the Marvin Gaye case, Williams v. Gay. They allowed, so long as it was represented in the deposit copy, experts could extrapolate and also fill in the missing gaps.
Experts can speak, I'm just speaking practically, experts can speak all day long, but when the jury hears the deposit copy against the Led Zeppelin recording, no jury of lay people is going to think they're substantially similar.
Unless you strip out the performance elements. And if you strip out certain performance elements, like the harpsichord...
Sure, unless you redo the deposit copy.
Well, no. In other words, some things are accompaniment, the harpsichord.
But look, what happened at trial, you're making it sound like we took the deposit copy of Taurus and the deposit copy of Stairway to Heaven, and that's all the jury saw. There was extensive trial testimony about each of these things you're talking about, the pitch, the arpeggios, the descending elements. All of that was gone into at great length by the experts, was it not? Although there were dueling experts.
I would agree with that, but I also agree.
Well, then what's the prejudice to you?
The prejudice is that even so, the court and even the panel opinion basically said that you could never use a sound recording in a pre-76 case, and that has never been the law in 110 years. This is the first time a panel or this court has said you cannot use a sound recording in a pre-76 case. It's not the law. But to be more specific,
So how do you distinguish AFCO Music, which held that?
I'm sorry, ACCA Music versus what?
The Levere, which held that it's not copyrighted, that the performances and sound recordings are not the copyrighted work?
Performances and sound recordings aren't the copyrighted work, but Goldstein v. California, 1973, Supreme Court opinion says compositions are embodied in the sound recording, and that's how you get through that case. And it's very clear that's a Supreme Court case which we have to follow.
Can I ask
yes,
you?
It's not. I'm sorry. Can I finish?
Yeah.
Thank you. I appreciate that. It's not the sound recording and the performance elements that we're copying. It's the composition embodied in the sound recording. And the Congress invited broader scope when it said piano rolls can embody composition. If piano rolls can embody the composition, then so too can an album, and so too.
But that's not what the copyright law says. If we reject your analogy, I mean, there was a reason, of course, that Congress put piano rolls in, because it was in direct response to the court's ruling on piano rolls. But you now want us to say, well, by putting in piano rolls, they really also meant sound recordings, which they explicitly excluded. So my question is, if we reject your analogy on the piano rolls, then don't you lose on this sound recording argument?
No, because it's not the sound recording copyright, it's the composition embodied in the sound recording. Composition can be embodied in mechanical reproductions. A piano roll is a round cylinder which plays back composition, no different than an album which is flat, which has bumps and grooves and plays back composition. If an instrument, a mechanical reproduction can infringe on a composition, so too can it identify the composition at issue.
Can I ask you just on your fairness point?
Yes.
Am I wrong in thinking that after the 1976 Act was enacted, that your client could have just used the sound recording as the deposit copy?
You know, it's a loosey-goosey argument that defendants made. They basically said because they cherish the intro of Stairway to Heaven and they cherish the solo part of Stairway to Heaven, it doesn't appear in their deposit copy. So, you know...
That's not an answer to the question. Again, it would be helpful if you would answer the question, which is whether your client could have, after 1976, copyrighted the album and restated it essentially into the composition you're asking us to consider as the copyrighted work.
Sorry, and let me be more specific. There's law that says that you can't expand a copyright once the initial copyright was the registration was actually filed. So, but there is the law in 76 which says that those parts that are unpublished, you know, could technically, excuse me, let me restate that. Unpublished songs get copyright protection after 78.
Right, and your point is that the sound recording embodies such a more fulsome and richer version of the composition that it's really a different work in a lot of ways. And so that's why I thought the argument on the other side against you was correct, that you could have avoided all of what we've just been debating for the last 20 minutes by simply, if your client had simply used the sound recording as the deposit copy after the 76 Act had been enacted.
I don't think we can expand the scope once registration has happened. The argument that defendants made was the solo and the intro are actually copyrightable because, they're unpublished aspects of an individual work. It's really a weak argument because, but it does show one thing. Copyright exists at the moment of creation. That was the law based on common law in 1909, even before 1909, and up until 76. There's been a big distinction and a big misunderstanding, I think, with many copyright attorneys, the confusion between as created and as registered.
But then the federal copyright supersedes the state common law one, correct?
Well, in 76 it does. In 1909 it does not. And we have ample legislative history which shows the 76 Act history definitely supports plaintiff's position here. And it talks at length about doing away with the dual system and moving to the single system. And so the first time Congress has ever talked about this issue of state common law copyright and federal copyright, statutory copyright, was not in 1909, not in the many years we have, because it was always viewed as always viewed as jurisdictional. It was in the 76 legislative history, 67 years later. That's when the Congress commented on it. And when you look at the comment, they say, all states had equivalent legal and equity rights known as common law copyright. And it says, quote, House Representatives Report number 94-1476, and this is in our briefing too. Instead of a dual system of common law copyright for unpublished works and statutory copyright for published works, which has been the system in effect in the United States since the first copyright statute in 1790, the bill adopts a single system of federal statutory copyright from creation. This is the first time Congress has discussed this issue. And the issue was, we're sitting here 110 years later trying to figure out what Congress meant 110 years ago. It's never been an issue, and the reason it's the first impression is because it was always understood to be jurisdictional. It was a dual system, state common law, and then for unpublished works, which we have here, and then federal statutory scheme, and that's the dual system that was done away with a single system in 76.
I just want to make clear then your position. If we take the position that the copyright is limited to the deposit copy, then the whole trial was irrelevant in your view? Do we not look at anything from the trial?
I think that what happened in the trial was a travesty of justice because we were in an artificial Orwellian world comparing two things that Randy didn't write and which Jimmy Page didn't read. So
what's my answer to the question?
I think the answer is that we need a retrial and we have to remand.
Okay, no, but let me go
sorry.
back because I understand you would like a retrial. But if your copyright by virtue of law is limited to the deposit copy, what would be different? You want a retrial on that? If that is the law,
yes,
then what would be the retrial?
Very simple, and I'm going to reserve my time here because I just looked at it and it's 8:38. I want to keep that for rebuttal, but this is very simple. The prejudice analysis of Three Boys Music, which holds in this case. Absent intent to defraud, there's none here. Absent intent to defraud or prejudice, there's none here. Broad and deferential consideration of looking at other evidence. If the Copyright Office had lost the deposit copy, we'd look at the album recording and the composition embodied there too. There's no prejudice to the other side. We have broad and deferential consideration.
In other words, if the law is that the deposit copy is the four corners of the copyright claim, there's nothing else to retry, correct?
If that's the law, but
I understand that you disagree with that.
And
I have a question.
Go ahead.
Sorry. You mentioned
Is that going against my time?
Williams
Yes.
versus...
Yes.
It's our time, not yours.
It's
Okay.
Williams.
It's our time to use,
Very
not
well. We're here
yours.
for you guys.
You mentioned Williams versus Gay, and I just want to understand what your view is on how that guides us or cabins our options here.
Okay. I think that the first time in 108 years where the album recording wasn't used and the trial court constrained the scope of what can be considered was the Gay court. But in the Williams v. Gay court, they at least allowed them to extrapolate and do representation. So long as it represented in some way in the deposit copy, they were able to extract that and play what was in the album recording. But you couldn't play something that wasn't represented in some way. In other words, if it had a chord, a C chord, you could extrapolate the arpeggio from that, even though if it wasn't listed there. And I think that's the issue at issue here too. Then it was constrained one step further by saying no sound recording ever. We will never look at it in the 76 case, and that was the panel opinion, saying that in any 76 case, we do not look to any composition embodied in the album recording. All we can look at is the deposit copy lead sheet. If that's the case, it'll disenfranchise hundreds of thousands of pieces of work, some of the greatest works we know. It'll affect songwriters forever, including Freebird, including Led Zeppelin's Stairway to Heaven, which they have protected for 40 years. Even though those elements that are most critical to that song are not even in their deposit copy, it would forever change things. And to put things in a magnitude, Stairway to Heaven's 11,000 notes. The deposit copy is 400 notes. It represents 3.6% of the composition in Stairway to Heaven. No different, at least, and no different does that have inaccuracies and absent the most critical aspects of the music which Jimmy Page has identified as the solo in the intro. We have inaccuracies too in ours. If record companies and publishers recognize that this would forever disenfranchise, if they understood that filing a skeleton outline of maybe a page or two, when a full score would take 20, 30 pages and about $50,000, it would have changed the whole concept of how we look at these things. And luckily, the 76 Act changed that. I'm going to reserve that time right now. I hope I answered your questions, and thank you. Humbling experience being before you all. And Ring v. Arizona, great case.